and you enjoy this nice warmth in Bangkok, which is slightly different from Japan. I think I heard it's a wonderful weather in Japan at this time of the year. Now we are here for the afternoon session, and we have two things to do. So we have the symposium from the students from Thammasat and Chuo, and it's going to be the first of our collaboration project, and it's marked this opening of this collaboration center that we had open ceremony this morning as well. The title of the symposium, student symposium, is Street Privacy and Defamation on the Internet. The topic that has been the talk of the town in Thailand and I believe in Japan as well for some years. And after that, we will have a break in this room, so no need to move out. The drink will be served here in this room, which is cooler than outside, I think. And that is followed by the second session, which is the panel discussion on education and global human development, where to from here. And we have a wonderful list of discussions with us today. So ladies and gentlemen, first of all, let me welcome to the floor Associate Professor Narong Jaihan for the opening remark.
Yes, Thammasat and Chuo, ladies and gentlemen, it is my great pleasure to welcome all of you to the first Chuo Thammasat Symposium, our first ranking event of the Chuo Thammasat Collaboration Center at Thammasat campus. Education is an important measure for human development. Education is regarded as the fundamental basic of changing and improving our society. Chuo University and Thammasat University, we both have the same mission in providing education that fosters global citizenship. We do hope that the cooperation between two institutions would extend our capacity and open doors for students to connect with the global society. The two following events should show us some more details of our cooperation. One from perspective of students, the most important stakeholder in education, and another from perspective of academics and practitioners who are currently working at the heart of human development. I would like to thank both student discussants and distinguished panelists for being the main part of our branching collaboration, even between Chuo and Thammasat University. I do hope that all of you will enjoy both student presentations and panel discussion. Thank you very much.
Thank you, Professor Narong. Now let me invite to the floor Professor Dr. Masahiko Omura, the Executive Regent of Chuo University. So you have
First of all, let me say my deep gratitude to Professor Narong and also Associate Dean Thammasat University. I'm afraid Osaka University does not necessarily have enough space to accommodate all of its activities in this campus, except you have some other campuses, but in this campus it's not so spacious. But so it must be a very generous decision in right now to allow us to open an office here. Okay. Now there are many students at Chuo University. They are the students of my seminar and Professor Takeichi's seminar. They are all undergraduate students. And today's topic is about free speech. Free speech is a fundamental right guaranteed by every constitution in the world. It is the basis of the democratic society. However, it sometimes causes conflict or collision with other fundamental values. Students of my seminar are law students, and they will talk on some legal issues in Japan. Students of Takeichi's seminar, who are sociology students, will talk on some international issues from sociological viewpoint. So, please enjoy the presentation of our students. Thank you.
Thank you, Professor Dr. Omura. Now, without further ado, ladies and gentlemen, let us hear from our students, and let me invite the moderators for this student symposium.
Today's session will be divided into 3 parts. The first is the Chuo Law presentation, followed by the Thammasat Law students presentation, and ending with the Chuo Sociology presentation. We will take questions at the end of each presentation. So now we would like to invite the Chuo Law students to come and give their presentation.
Taju Ken NDT Daibu Jack. I am Ken Nishijima. I am sophomore at Chiu University. I study law because I want to be a lawyer. We are belong to the Mr. Oma Seminar, specializing code of civil procedure through mode good or not case. Sorry, case not, and so on. So we are talking about this theme: free speech, privacy, and information on the internet from the point of view of law. After our presentation, the next is insert presentation. Then Mr. Isino will talk about the same thing in different perspectives of sociology. Concretely, our seminar consists of 4 presentation groups and focuses on details of the issues. First, general expression about free speech by Ms. Naoko Kasai. Freedom of expression has a variety of meanings, so shows the understanding about it in Japan. Second, judicial principle of the conflicts between free speech and privacy or information in Japan by Ms. Shiori Takawa. Third and fourth, our peculiarity of internet. To begin with, refer to the judicial precedent as Supreme Court about information on the internet by Anna Takayama. Next, introduce social problems of privacy invasion by Ms. Natsuho Ito. A lot of issues of free speech or internet occur all over the world. First, Japanese people thinking were about these problems. Let's begin.
Today, we would like to talk about free speech and information and invasion of privacy on the internet. First of all, we will explain some of the problems in Japan. For Japanese, especially for young people, the internet is a key communication tool. About 60% of young people in their 20s use Twitter and Facebook. They use the internet more than 2 hours per day on weekdays and more than 3 hours per day on weekends and holidays. In fact, I chat with friends and upload posts day after day on 2 or more social media. This is quite common for Japanese young people. In fact, many young people use the internet more than they watch TV. What's more than 60% of people in Japan use smartphones. The number of internet users is increasing. Now, the internet is both a communication tool and mainstream entertainment. Not surprisingly, various problems occur related to internet use. One of the big problems is the great variety of illegal and harmful information. For example, defamation, invasion of privacy, child pornography, illegal drug sales, and unlawful use of images. All of these occur frequently. In Japan, we try to solve these problems with and without using the law. First, it is possible to use filtering software. This can prevent access to harmful information on the internet. These days, almost all internet providers offer filtering software and services. Providers are also expected to self-regulate. Providers and users enter into contracts that prohibit uploading harmful and illegal information. If users breach these agreements, providers can terminate service. In addition, reverse search engine optimization, SEO for short, is operating. Reverse SEO reduces the search ranking of a particular website. However, the amount of harmful and illegal information on the internet is increasing. It has become easier and easier to copy information and spread harmful and illegal information over and over again. In this presentation, we focus on defamation and invasion of privacy and how to solve these problems under the law. First of all, what does the Japanese constitution say about free speech and defamation? Free speech is now a basic right under the constitution and in Japanese society. It is widely recognized that free speech encourages democracy. It is not evil. However, Japan's former constitution did not protect free speech adequately and permitted restrictions on this freedom. Nevertheless, today, the right is not unlimited. The Constitution says the right of free speech shall be balanced with concerns for protection of social welfare. One of the restrictions on free speech is the right of reputation and the right to privacy. These rights to privacy and reputation are not directly stated. However, they are guaranteed under Article 13, which ensures the rights to life, liberty, and the pursuit of happiness. In Japan, reputation is understood to mean society's objective evaluation of an individual. Privacy is the secrets within our private lives that are ours to keep or reveal. An invasion of privacy is more difficult to recover from than a defamed reputation. Generally speaking, it is possible to recover your reputation, but it is impossible to recover your privacy. In some cases, free speech and reputation and privacy are in conflict. Thus, balancing is required.
So, how does Japanese law view one's privacy and reputation? Why is free speech restricted by these rights? Why is speech defamation or invasion of privacy? We're going to consider these questions under the Civil Code and Criminal Code. In the Criminal Code, defamation is a crime. If you allege or spread the fact in public or seek to harm someone's social reputation, you can be punished for defamation. The punishment can be up to 3 years in prison or 500,000 yen, which is 135,000 Thai bahts. However, some exceptions exist. If someone alleges or spreads the fact in public or seeks to harm another's social reputation, there is no punishment for defamation in some exceptional cases. The Penal Code prescribes a social provision for matters concerning the public interest. A defendant must show 3 elements to avoid punishment. First, the information revealed is in the public interest. Second, the information promotes the public interest. Third, the information revealed is truth. If you reveal information about suspects in criminal cases, you need only prove that you are promoting the public interest and the information is true. When making accusation towards political candidates or members of the cabinet or local assembly, you need only prove the accusations are truthful. Even if the defendant fails to prove the information is true, it is still possible to avoid punishment if the defendant can throw substantial reason to believe the information is true. Their exceptions come from judicial efforts to balance the freedoms of speech and protection of personal reputation.
Next, we would like to share with you the first Japanese Supreme Court case concerning defamation on the internet. Begin with a fact. The defendant pushed false information about the company on the website, and he defamed the company. He was prosecuted of defamation under the criminal code. As Farrago explained, the defamation can be punished under the condition that his or her idea is true and is revealed in public and it promotes public interest. But the defendant failed to prove the information was true. It is, however, still possible to avoid the punishment if we can show the substantial reason to believe the information was true. In this case, the key issue was the internet, what substantial reason is. The Supreme Court ruled that the reasonableness depends on whether defendant have a reliable materials and reasons. And the case turned on whether the defendant could show that his reasons for posting and information were reasonable. In this case, the defendant claimed that the rule should be applied. The defendant said internet users is difficult to show reliable materials and reasons. Also, the reliability of information on internet is generally less than that of mass media. In addition, the victim can be easily bring counter-arguments to bear on the internet. The Supreme Court, however, denied the defendant's opinion. The court adopted the Supreme Court rule. The defendant must have reliable materials and reasons. The court said there was no reason to distinguish between defamation on the internet or elsewhere. The court found the decision in the first trial wasn't enough to protect victims. This is because some people believe the fact is true. What's more, if victims bring counter arguments, they can restore their reputation completely because the information on the internet is led by a specified number of people. Furthermore, the reputation of the victim may be damaged even by counter arguments.
Next, we would like to talk about a civil case in the civil court. If a defendant has defamed another, the plaintiff has three main remedies available. First, a tort crime. Second, fabrication of apology. Third, termination of fabrication. Fabrication of an apology in the plaintiff media is an action by the defendant to help recover the reputation of the plaintiff. It can be ordered as part of the court decision. If the plaintiff raises a claim in court and/or demands fabrication of an apology, the plaintiff must show an illegal act harm to reputation, causation between the act and the harm, and intention or negligence. However, if the defendant can show the information revealed is in the public interest, the defendant is promoting the public interest, and the information is true, then the defendant has no tort liability. Even if the defendant fails to show the information is true, then the defendant is not liable in tort if the defendant can show reasonable reasons to believe the information was true. In addition, when a defendant is likely to defame another, for example, is about to publish information in a magazine, the plaintiff can call for an injunction to stop publication. In such a case, the plaintiff must show that the information is not true or the fact is not in the public interest. The defendant is not promoting the public interest, and it will be seriously difficult for the plaintiff to recover its reputation. Moving from defamation to privacy under the civil code, if an individual invades another's privacy, a plaintiff can bring a tort crime and stop publication. When the plaintiff sues the defendant, he must show that the information is personal, or people will believe that it is the plaintiff's personal information. People don't know the facts, and people think that plaintiffs don't want others to know the fact. The defendant is free from liability if the defendant can show that the plaintiff has allowed or is going to allow publication of the information, or the information is in the public interest and there are reasonable reasons to publish the information. When the plaintiff risks disclosure of privacy, the plaintiff can demand an injunction to stop publication. For this, the plaintiff must show publication of reasonable reasons to disclosure the information, and it will be seriously difficult for the plaintiff to recover his or her privacy.
Relating to the civil court, we would also like to explain a case concerning privacy internet. In the past, the right to privacy meant that your private life wasn't open to others without reasonable reasons. But now we have a lot of chances to send and receive information. So the right to privacy includes the right to control your information. In Japan, legal controls are imposed on internet service providers and entrepreneurs in order to protect the right to privacy. However, a variety of issues have arisen recently regarding internet use. One example is search engine problems. Last year, the Tokyo District Court ordered Google to place a link to a website that suggested a plaintiff had committed a crime. These decisions were given to internet search engines such as Google, not to the first-hand expressors, because internet users can hardly access search information without search engine. As a result of the decision, people have begun to care about the right to be forgotten, which refers to the right to the erasure of personal information that is disadvantageous for a person. However, this court decision didn't guarantee the right to be forgotten exactly. In the future, the to generate more and more discussion in Japanese society. Another concern is the right to privacy conflicts with the right to know. The right to know is also guaranteed by the Japanese Constitution as part of free speech. Regarding internet use, there have long been concerned that Google Street View invades our privacy. In the past, we could see people's faces, call license plates, and nameplates. But now, Google lowers the height of its cameras, obscures faces, license plates and nameplates, and informs local government before filming. From those Google's efforts, Japanese courts have said that Google Street View doesn't invade privacy. Another issue is the spread of information about juvenile crime. The Juvenile Crime Act says information shouldn't be revealed regarding those under 18 who have committed a crime, because the primary purpose of the act is to promote juvenile rehabilitation. These days, however, such information is often leaked on the internet, particularly related to juveniles who committed serious crimes. This act regulates media, such as newspapers, magazines, televisions, and books. But it doesn't regulate information linked by ordinary citizens. Why information, including individuals' real names, relates to the right to know, it also can invade the privacy of juveniles. From these cases, we have to consider two things. One is, what is privacy? The other is, how can we balance the right to know and the right to privacy? We would like to discuss this point with you, as well as other aspects of our presentation today, including defamation and other issues under Japanese law. This is Mr. Oma's and his presentation. Thank you for listening.
And now we would like to open the floor for questions regarding this presentation.
May I ask a question? Thank you very much for your very nice presentation. Can you tell us what the Japanese word is for privacy? That's why I asked it. My question was, what is the Japanese word for privacy? When you talk about privacy, what word do you use in Japanese? Privacy. Which is just a borrowed word from English. So why do you think there isn't an older, more authentic Japanese word for privacy? 100 years ago, there was idea of privacy in Japan, or is that a relatively new idea?
Thank you for your question. And
Really?
it's possible.
Maybe liberty not to interfere by others. I don't know what to say. Japanese like using American words. I don't know.
Well, it's a good thing to consider. Very idea thing.
I would like to just maybe follow up on that. In your study of privacy, have you seen any differences between maybe a Western view of privacy and a Japanese view of privacy? Are there any differences, similarities that have surprised you or that you have identified? Or do you think they're exactly the same?
As we use privacy in katakana, so our concept of privacy is very similar to your friend country. So I think it is very similar. So not. Yeah, okay, I think so.
I think Japanese privacy is more wider than Americans. Japanese privacy includes address or names or phone numbers. Yes, that's I think. That's it.
I think Japan is more strict to protection of privacy. Concept itself is same.
Is there any more questions?
For the wonderful presentation. So the question is, I'd like you to have an idea about how to balance the right to know and right to privacy perspective of Japanese law.
A member of our senators
So I answer the question. So I'm Omura Seminars. So privacy is very new concept in Japan. So it's difficult to say how to balance. But one of the criteria is that, so what is the information? Your name, address, it is important or not? Or if invades some of the information, you damage it seriously or not? Or if you reveal the information, it is promotes public interest. So we balancing to see public interest and the information, how important information or how damage or the privacy.
Okay, thank you for your presentation. And the second part of this session will be the Thammasat Law Student presentation. Our members consist of Sirirat, Kanta, Sukjai, Sirawit, Tan, Saharat, and Thanat Nan. Our presentation will be divided into 3 parts: an introduction, discussion on privacy law and on the freedom of expression, focusing on the Computer Act. So without further ado, this is our presentation.
Good afternoon, special guests, and welcome to Shiro team. The topic that we are going to discuss today is about the freedom of expressions and privacy in the digital age. The information that we are going to be presenting today is in above. There are the general statistic, the internet provider, the related law, as well as the Thai legislative process and case study. Let's begin with our 2014 survey of Thailand internet users conducted by EDDA, or the Electronic Transaction Development Agency. The survey shows us about the differences in the gender, occupations, educations, and age. Let's begin by the gender. As you can see above, the difference between male, female, and transgender. The most of the Thai internet users are female, but a little bit different between male and female, followed by the female and transgender. For the next sort is about the educations. As you can see, that's the majority of the bachelor degrees are the internet users. And what about the occupations? More than half of the internet users comprise of the working people, and the second group of the largest group is students, as you can see. In terms of age, the common sense would tell us that the teenagers would involve in the internet usage more than mature adults, right? But this survey shows us that more than 20% of the internet users are adults.
Would you like to know which smartphone application are most popular in Thailand? Facebook ranks as the most popular application and followed by Line. The next is Google+. Next, moving on to the topic of internet service providers in Thailand. It's important to note that there are more than 15 internet service providers. The popular ones are TOT, 3 Broadband, and True Online. Let's take a look at the background of related laws, which are Computer Act 2007 and Personal Data Protection Draft. We went on to different types of parliament, which are unelected parliament and elected parliament. Before the Computer Act 2007, it was introduced under the rule by the unelected parliament. And for the personal data protection, it took time in the beginning of this year by the unelected parliament as well. This layout may look complicated and hard to understand, so I will give briefly information. This is about our legislative process. The previous one was 2007 Constitution of Thailand, which is the outcome, and the other one is a Constitution, which is 2014 Temporary Constitution. The similarity of these two processes is that it consists of 3 stages for the bill approval, which are, first one is bill acceptance, second is amendment, which means to check or to correct the detail in the policy that has already been accepted. And the last one is voting for the approval. But the difference of this process is that, for the previous one, is that the 2014 Temporary Constitution, the 2007 Constitution, which was the previous one, the legislative process for voting for the approval, this is the last stage, is
complicated. So that means whenever the draft or the bill is disapproved, there are many ways to bring it back. But looking at our current situation, which is 2014 Contemporary Constitution, is under that. The legislative process is very short, so that means it's faster to get the bill to become the law than the previous one.
For our next topic, I would like to inform you about the overview of the public concern in Thailand. As the social network are used definitely in each culture. For Thai cultures, we use this as a channel that users can share their experience in everyday life, so it may involve the incident or the people in that form of such a photograph or video. Furthermore, the photo of those people maybe doesn't always ask for the permission from that person in photograph. Like this is a Facebook fan page named BTS Cute Guy that they're sharing the snapping of the good-looking people or cute guy and share it on Facebook without permissions or censoring. And another incident that's occurred the last few years during the anti-government protest is the spreading of the photograph of Mr. Daijiro Enemy, who is the Japanese press. But this is different than the previously I mentioned one, because this is the spreading of the photograph that gives the consent by Mr. Enemy through the social media like Pantip, which is the discussion web board like Nishinari in Japan.
For the most recent social media trend in Thailand is a campaign to promote good manners in using BTS Skytrend. This campaign exists in Facebook fan page, which publicizes pictures of people who have wrong use or inappropriate use of the BTS Skytrend. However, these pictures are censored as to hide the identity of the people in them. And the act of censoring these pictures concerns for the personal rights of the people within these pictures. And this is an overview of the general statistics, social media trend, and Thai social media culture. Thank you.
Ladies and gentlemen, what my colleagues presented was general statistics about internet usage in Thailand and the Thai legislation process, the present and public concerns in Thailand right now. And now I'd like to demonstrate the outline of our presentation today. First, we'll start with the privacy law, and then we'll end with the freedom of expression for Computer Act 2007. Ladies and gentlemen, to begin with the privacy law, I'll give you a brief overview to see how rights work in Thailand. The perception of rights in Thailand can be traced back during the Ayutthaya in terms of federal system. In the system, the king is in a position to give the privilege to the people as he deems fit. Therefore, the relationship in the society of that time is sustained by interdependence and compromise. Moreover, being the land of Buddhism can have an influence on the Thai perceptions as well. For example, the concept of middle path emphasizes the moderation and implies conflict avoidance that has been interpreted as a hindrance to the development of human rights in Thailand. And until the First Amendment of the First Constitution in 47, the right to fair trial was added, and this could be considered as the first movement of human rights in Thai society. Ladies and gentlemen, it is clear that Thai society may not be a breeding ground for privacy rights. Nevertheless, recent movements has been given rise to public concerns about privacy rights, particularly information privacy. This comes to the current law, which is the Official Information Act 1997. This law has a section on the protection of personal data that are contained in government files, and a code data protection principles and laws that have been passed in Western countries. It is important, ladies and gentlemen, to note that this law is focusing on granting public access to official information in the government hands, which has not been accessible in the past, rather than the protection of the information privacy. Thus, data protection is only a bonus that comes with the legal package, and can lead to some problems as I'll illustrate as follows. First, there are no provisions guarantees the protection of personal data in the private sector. And second, the interpretation of the law is extended and contrasted with the intention of the drafter. Third, it gives so much power to the governmental organization to consider whether the data should be protected or not. And last but not least, we are aware of that time that we do have some laws concerning the protection of personal data in the private sector, such as the Credit Information Act, Information Act, Securities Exchange Act, or maybe Accounting Act. But however, those laws, ladies and gentlemen, were created to solve some specific problems for some specific areas, and this is why it occurs recent concerns of having general law to create a common standard.
And after you've listened about current laws, now let's move next to the incoming law, the Personal Data Protection Draft. First of all, I would like to tell you all about the background of the draft. Since our technology improved much in these 10 years, especially when social network and smart devices were introduced to Thailand, we photo, chat and share much, and that is the reason why privacy is intruded more and more, and not to mention the business sector. Though Thai has some privacy laws, but there is a problem, like my colleague just said, that we only have sectoral law. And this draft aims to solve these problems. Please, our lawmakers study OECD guidelines on the protection of privacy and transborder flows of personal data. And this is a comparison of OECD and the draft section. I'll give an example of how the principle appear in the draft. This is the section. This is the collection principle, the first principle of OECD's. It says that there should be limits to the collection of personal data, and any such data should be obtained with the knowledge or consent of the data owner or the data subject. And this is section 22 of the draft. It says that in terms of collecting data, the data controller shall inform the collection to the data owner before or when collecting that data. As you can see, the data is obtained with the knowledge of the data subject, same as it is in the principle. Despite the fact that the draft follows OECD's, there are some problems. These are some problems occurring in the draft. And let's see an example. Section 17, it says that the committee shall allow the accused to present the facts, argue and show the evidences, except when it is necessary and urgent. The problem is, the draft is a criminal law since it has punishment clauses, and there should be no exception of the right to defend themselves, the accused to defend themselves, because it contradicts to the principle of the Universal Criminal Procedure Principle. Furthermore, here's the social response about it. People now realize that the digital economy draft set, including this personal data protection draft, violates the rights and spreads it on the internet. And this is the page of the netizen or internet citizen of Thailand. They made a campaign to journalists who are against this, those draft set. And you can see that it is only 2,946 people to reach 25,000 people. And some people even made that page to give us suggestions for those drafts. To sum up, personal data protection draft has many advantages. but many problems either. I think the social response would trigger the concern and the government to consider about it and fix it.
So now, ladies and gentlemen, as my colleagues have introduced you about Thai concept of privacy and Thai law. Now, let's consider the real incidents that occurred. On 23rd December 2014, Minister of Information and Communication Technology gave an interview to the press that the government have been spying on all the messages stemming from LINE applications, which only in Thailand there are more than 40 million messages sending per day. So most of us using LINE's contact to other persons. So the next, within 24 hours, LINE Thailand have sent the message to the users and post the status on Facebook page, say that according to the Minister of ICT's interview, LINE Thailand has contacted the ministry and have been confirmed that there are no spying on any messages because LINE has classified all the messages in the system, and it is impossible for third person to read the message. Please be sure that LINE has no policy to give the data to the third person. Now, I would like you, our special guests, to consider these questions. First, does the Ministry of ICT have authority to interfere with LINE? And if it does, how will they do it? So, the first answer for this first question is by virtue of Section 14, subsection 3, Computer Crime Act. ICT can request the data from the service provider, but it has to asking for the court permission first. So, in this case, the ICT has no authority to interfere with LINE because they didn't follow the legal procedure. So, the next question is, does LINE Thailand have the right to respond to these intruding actions? Well, the answer to this question is we have to understand the data first, the basic information first. Well, the data that LINE have duty to hand into ICT is the log file or the log traffic. For example, such as IP address or the time that the user logged in, but not the content of the data, like our conversations or the picture that we send. So, furthermore, LINE Thailand may file lawsuits against ICT for computer crime under Section 8 Computer Crime Act because ICT is using a sniffer, which is a spying machine. This is how the sniffer works. The middle machine is the sniffer, and it intercepts the data between the user. So the third question is, what is the consequence of this case? Well, the answer would be first, it definitely will give the Thai government an aggressive look, and second, it will discredit LINE as a service provider, and last but not least, it will affect the economics in the digital age. Speaking of the sense of opening investment, like Facebook haven't opening the office in Thailand yet. And the last question is, next. And the last question is, what is the reaction from the citizens? Well, in other countries, this incident may lead to the big protest, but in Thailand, as my colleague has described about concept of the middle part, it's just lead to either silence or ignorance. So, thank you.
Okay. my colleague presented about privacy law, and the next is about Computer Act, which is affecting the freedom of information on internet. The first topic we would like to talk is about background of Computer Act. Computer-related Crime Act, or Computer Act, was introduced in 2007 and proposed to Parliament. Although a legislative process runs exceedingly faster than a process and the elected Parliament, this process leads to some problems. In the presentation, we would like to discuss three main problems, such as defamation and compromise offense and self-censorship by providers. And moving on to the defamation problem. First, this is the background of information under the Computer Act. Originally, Criminal Code has an often relating to Document Act. According to the Thai Criminal Code, document means a paper, and yet it defines only about a paper, not covering an online transaction or internet information. Therefore, there is a gap in the law. And that's why our government tries to solve it by enacting the Computer Act. Unfortunately, it leads to some defamation problems. At this point, you might be wondering why the Computer Act leads to defamation problems. The main reason is an unclear legal provision. And this is the comparison table I want you to focus on. And you will realize that Section 41 of the Computer Act, which states that to import data which cause damage to the third party computer system, and this can also be interpreted as defamation of criminal code, even if it is originally used for crime relating to document. And please look at this picture and note that nowadays both sections are most commonly used in defamation lawsuit. It's both under a criminal code and a Computer Act.
Okay, on the next topic, we will discuss 4 cases regarding the information laws under Criminal Code and Computer Act. The first case is Andrew Hall, a national fruit. Andrew Hall is an NGO who has another result for interviewing migrant workers of National Fruit Corporation to the public regarding violating human and labor rights. The National Fruit decided to file a lawsuit on Andrew Hall for criminal defamation and computer-related crime act. And the next case is Tower Navy and Phuket One New Agency. Phuket One is a new website in the province of Phuket. The website published a report that includes information from voluntary investigation piece that alleges some Thai naval force have been profiting from smuggling of any Rohingya migrant, fleeing violence in neighboring Myanmar. So the Thai Navy have filed criminal charges against 2 journalists and their company over reporting Thai military personnel to human trafficking. They accused the journalists of knowingly publishing false information and committing slander. And the third case is about Late Chen Kong Tham and Islam News. Late List is a Secretary General at the Office of Administrative Court, has sued Islamic Agency for publicizing leaked news.
Ladies and gentlemen, and the last but not least is about Supanya Kwangrong and TV Channel 3. Supanya is a former journalist, media rights activist, and coordinator of Freedom Against Censorship Thailand, or FACT, and also a Thai Netizen Network, or TNN. Currently, she is a member of the National Broadcasting and Telecommunication Commission, or NBTC. In 2014, she and some of NBTC were in conflict with the Television Channel 3 regarding transfer to digital television system. She was sued under Criminal Code and Computer Act by Channel 3 after she had retweeted a text from some journalist to the user about Channel 3 history, concession, and its relationship with military. And here is our summary. We always might have known that the media was sued by a company, government, or government officer. But in this summary, you see that anyone can sue or can be sued, yet including the media, that is compare of Supriya case and the other case. If only individuals can see the benefit, they only sue anyone for information under the Computer Act. It is truly impossible. And well, we have just finished the first problem under the Computer Act, and it still have many problems, such as uncompromised offense and a self-censorship by the service provider. Yeah, that's how Thai people watch animation in Thailand. Well, since the Computer Act has many problems, we still have a flare. Let's see the citizen movement of the Computer Act problem. You see that not only some researchers decide and held public seminar about it, but some new agency also published about its problems. People gradually realize how the freedom diminished and become against its problem. Therefore, now the government tries to amend the Computer Act. We call that Draft Computer Crime Act of 2016. We strongly hope that all errors will be clear and everything will improve. And it can imply that information and other problems on Computer Act reflect significantly to freedom of expression. It's called a media, company, or anyone a self-censorship. And then it's continual lesson of freedom of expression. And this is the quotation is from Supriya after she was sued by Channel 3. Although we all know that this Computer Crime Act itself still has some problem for legal provision and interpretation. They use it as a tool to sue and lessen the freedom of expression of people. Since government officers like myself risk being sued, there's nothing different on other people as well. Therefore, all public figures such as politicians, companies, and government officers, please carefully think over using Computer Crime Act to sue anyone. Nowadays, we all live in the digital age. It will be better to isolate the fact or exchange our information to public instead of accusation. And thank you for your attention.
So in summary, our presentation was divided into 3 parts: an introduction, a discussion on privacy law, and on the freedom of expression, focusing on the Computer Act. Our introduction provided general statistics regarding internet usage in Thailand, Thai culture in using social networks, the legislative process at present, and interesting case studies. We then discussed problems and implications related to the privacy law and the Computer Act. We concluded with case studies illustrating such problems. So now we would like to open the floor for questions regarding this presentation for the Thammasat team.
Thank you for your presentation. You mentioned about self-censorship. Could you clarify more in this matter?
And the problem of self-censorship by service provider, because Section 15 of Computer Act still lacks of clarity and reasonableness in specifying the liability of service provider. And that's why the service provider must censor themselves of content within the service. If not, they are likely to be strongly prosecuted. Yes.
Thank you.
Are there any other questions?
Just again, to follow up on that, so because there's self-censorship out of fear of being prosecuted. So what kind of limitations are imposed by those artists or those authors upon themselves? How do they determine how much to self-censor?
Actually, in this great and recent situation, and it's unclear, yeah, because the Section 15 is unclear of liability of service provider, and that's why they might censor themselves because they are want more safety. Yeah.
So sometimes they executive in the press, they just not allow the press to present to the public. Sometimes they just not present anything.
Do you see this self-censorship changing? Is it increasing? Is it lessening? Does it go like this? What, over the past year or so, 2 years or so?
It's increasing because of this act. And actually our case is about Thai culture censorship by porno or something like that. Yeah.
And frankly, about the statistic of censorship is not unclear because now you know that we are our current situation is affected
to express anything on broadcasting online or on TV or something.
Very interesting. Thank you very much.
Thank you for your questions. Now, I would like to invite the Chuo Sociology presentation.
We talk about freedom, expression, and understanding in the era of diversity from the sociological point of view. This is table of contents. We will take an example of an incident that caused a confrontation between free speech supporters and those against defamation. Do you know Charlie Hebdo shooting? On January 7 this year, two gunmen stormed into a newspaper company, which put the satire of Muhammad on its magazine. The shooters killed at least 12 people. People supporting for freedom of expression raised I'm Shari campaign. Muslim French raised I'm not Shari campaign. Muslim French felt insulted because of the satire, but it is difficult to legally identify the satire as defamation. The Shari Hebdo incident raises a new issue of freedom of expression in the era of diversity.
I talk about French nationalism. French nationalism has two aspects. An aspect of the Western civilization and the uniquely French aspect, which is called racism. The French Republican ideas as a part of the Western civilization put a high value on freedom, equality, and human rights. Racism in France, compared with American individualism, is characterized by its collectivistic approach to the principle of the separation of religion and the state. Some social problems are caused by these uniquely French ideas.
I'll talk about discontents of Muslims in France. We argue that the Charlie Hebdo shootings is not a confrontation between religious civilizations, as some argue. We think it is about double standards in French Republican ideas. Here is an example of double standards in France. Justice Charlie is a message to support freedom of expression. On the other hand, Muslim French felt their right to freedom of expression were violated by a law which bans bail in public, an example of racism. French people, including Muslim French, all support French Republican ideas and freedom of expression. Only that their interpretations of freedom of expression are different.
ISIS also has its own logic to mobilize people. Islamic religion is basically pacifist, but ISIS isn't. People are attracted to ISIS for two reasons. One is social discontent due to unemployment or discrimination. And people with social discontent seem to be increasing all over the world. The other is an internet strategy by ISIS. By posting their video on the SNS, they can recruit people who sympathize with them. Their propaganda video is edited very well. ISIS uses the second chapter of the Quran to legitimate murders, which says, don't fight against them near the holy mosque, unless they fight against you. But if they fight against you, then kill them. In short, we have to understand even ISIS has its own logic to legitimate itself.
So far, we have talked about three different worldviews: French Republican ideals, the world of Muslim French, the logic of ISIS. Now, we look back at the dichotomy between the Western civilization and Muslims in general. This way of viewing the incident is a collective deformation to Muslims, so to speak. The real dividing line comes here, between those who are supporting freedom, equality, and human rights, and those who aren't. We now live in a global society where our ignorance can easily lead to group deformation. We hope that globalization in education will help us overcome our ignorance. Thank you for listening.
Thank you for your presentation. Now we would like to open the floor for questions regarding this presentation.
Hello. Let me ask you a question. Do you have any concrete instances we can do for understanding foreign cultures and world views?
We think what we should do for understanding foreign cultures and worldviews is not only going abroad, do some sightseeing, but communicating. Communicating can make us share diversities of thinking and conceptions. We want to value precious opportunities like this symposium.
Thank you.
Are there any more questions? So, thank you for your presentation.
Thank you all students for these wonderful, excellent presentations. Now I would like to invite to the floor Associate Professor Aaron Jaiha and the Dean of the Faculty of Law for the brief comments on this presentation. Series of presentations.
I would like to say congratulations to our students from Chuo University and Thammasat University. Your presentation were very interesting and insightful. And this proves that all who are hardworking students and well prepared. Freedom of expression and privacy on internet are very controversial issues in this day. After listening to your pre-presentation, I think the most important keyword of today is balancing, and how to balance between freedom of expression and underlying or public interest. It's such a difficult question that requires a lot of discussion to find the best solution that might be different in each society. Sure, students have shown us that Japanese society have developed the solution by case law, while in Thailand, the development have been made in less formal activities by private sector factors such as NGO and media. It was a great opportunity to see the similarity and differences between these two societies. I would like to thank all students again and for your hard work on the research and analysis and think and more to the excellent presentation. I hope you will be keep this passion with you for future study and future career. Now, all of us, I invite you to give congratulations to the three groups by give a big hand for our students. Thank you very much.
That shall conclude the student symposiums. Now let's have a very short break of 5 minutes, and then we will reconvene again in this room for the panel discussion.
Well, very good. I teach media law. So, media law and communication law. So I'm very interested in your presentation. It's very learned a lot. I'll give you my card. Maybe the chairperson. You sort of act like the chairperson. I just tried to write down the information about the pieces, but I couldn't write fast enough. Yeah, so it's really? He was my student. So if you should call me. Next year.